Welcome to the Loud Little Ducky. Today, in the Owens v. Echard case, we're going to go over the motion to strike and telephonic scheduling conference. We're going to go over the original motion from Gingras, the objection response, and then which is from Woodnick, and then we're going to go over the reply from Gingras in today's video. So let's jump right in. Alright, so here is the emergency motion to strike and request for immediate telephonic scheduling conference assigned to Judge Matta in the Owens v. Echard, filed by Gingras. Pursuant to Rule 35A.3, Arizona Family Law Practice, Petitioner Owens, Miss Owens, or Petitioner respectfully moves the court for an expedited order striking the pleading filed on April 30th, 2024 by Respondent Clayton Echard, Mr. Echard, or Respondent, entitled Reply to Petitioner's Response to Respondent's Submitted Motion for Relief Based on Fraud. Such wordy titles. Separate and apart from the issue, Owens respectfully requests an immediate telephonic scheduling conference pursuant to Rule 76.1a for the purpose of discussing a potential change in the trial dates based on respondent's recent disclosure of new and untimely information which he has never previously disclosed. In addition, at the scheduling conference, Owens will raise a potential motion in limine seeking to exclude 3 newly disclosed witnesses, one of whom is the basis for the request to strike Mr. Echard's reply brief. Regarding the reply, the court should strike the reply brief in its entirety on the basis that it grossly violates the plain language of Rule 35A.3. The rule provides in a motion practice the reply may address only those matters raised in response. Emphasis added. Here, Mr. Echard's reply brief violates Rule 35A.3 because it contains extensive new allegations and information which were not raised in either in Owens' response or in Mr. Echard's original pleading. Specifically, Mr. Echard's original motion sought relief on the basis of fraud because, inter alia, he claimed plaintiff was never pregnant by defendant. Amended motion at 2:10 through 11. In addition, the motion argued Owens committing fraud intrinsic and extrinsic when she testified before Judge Duty regarding a sonogram on October 25, 2023, leading Judge Duty to uphold the order of protection. Amended motion at 7:23 through 25. In her response, Owens directly and properly addresses those specific issues and allegations raised in the original and amended motions. Now, in his reply filed earlier today, Mr. Echard offers entirely new arguments and evidence, including new evidence literally disclosed for the first time today. Specifically, the reply that contains following new arguments and evidence. An assertion that Echard... Okay. Let's strike that from my record. Owens, no connection, fabricated other medical records not previously mentioned in Mr. Echard's original or amended motions. See reply at 2:3 through 14. Discussion for the first time via medical records from 2016, which are dubious. Owens claims she had ovarian cancer and that she had an ovary removed, information that is patently missing from any of the medical records provided by Owens. An assertion that Owens concealed information from her expert, Dr. Medchill, by failing to disclose a prior cancer diagnosis and removal of ovary, something Owens flatly denies. See reply at 2:8 through 14, alleging there is no mention in Owens' expert report of John Kung Kale Chan, MD's records for Owen, who reportedly diagnosed her with, quote, real ovarian cancer, not something that just may be there, or Rebecca Yee, MD records for Owens, who said yesterday, meaning 8/30/16, you received ovary removal surgery and oophorectomy of your right ovary as well as a surgical abortion. Okay, I'm going to tell a really cringy joke that a radiology tech person told me about having your right ovary removed is the left is remaining because it's the only one left. It's very bad. But you could say, if you get the left ovary removed, that the right ovary remained intact. I know, cringy ovary humor, but you gotta laugh at some things. They're horrible jokes. Please forgive me. An assertion that Owens fabricated 3 ultrasounds. See reply at 4:8 through 9, asserting, to be clear, there are 3 ultrasounds that have been altered. 1 image used in the order of protection, current proceeding, 1 video, and 1 20-week sonogram. In addition to these completely new claims / theories, Mr. Echard's motion is supported by dozens of pages of new documents, which he only disclosed for the first time today, April 30th, 2024. Of course, none of this new information was contained in Mr. Echard's original motion for relief based on fraud, nor in the amended version of that pleading filed only days ago. Thus, Owens could not and did not address any of this material in her opposition brief. Well, you see, I don't think Woodnick thought that it would come up. It only became an issue and came up from reading your client's past medical history, and she failed to mention some key things from it that she has claimed. Many other fraudulent pregnancies, and ovarian cancer, and an ovary removal. Those are things you probably should tell your medical expert, along with PCOS and fertility issues, things like that. But it's not the expert's fault. He didn't have the correct info. I wonder if Gingras is like, oh my God, why can everything not just fall into place? And it's never going to with this client. This client, nothing is ever just going to be easy. I wonder how many times a day he is pissed off and cursing Owens. And like, are you kidding me? Why am I finding out all this stuff from opposing counsel and not from you? You're my client. You need to tell me everything you know right now, because I'm tired of being surprised by opposing counsel knowing things that you have left me in the dark about. That's what I would be saying. That would really piss me off, because that's who you don't want to find information out, is from somebody else other than your client. Mr. Echard's conduct in attempting to raise new issues and new evidence for the first time in his reply is improper and inexcusable. Well, like I said, they didn't know it was going to need to be mentioned, because they thought that she would put that in her medical history information. 1, that she gave to Mom Doc, and 2, that she gave to the expert, which she did neither. So now we need to bring this up, because people aren't getting the full information. So they have to see, is this information correct or is that information correct? And that's the problem with this case. And with Owens, you don't know what is what. Indeed, the violation is so egregious it would constitute reversible error standing alone. See Farji v. City of Phoenix 2018. Lexis 620, 9 through 10, reversing judgment on basis of new material raised for the first time in reply. The moving party may file a reply memorandum which may address only those matters raised in the respondent's memorandum. Emphasis added. Evans Withicombe Incorporated versus W Innovations Incorporated. Noting unfairness to considering arguments to which opposing party had no opportunity to respond. Varsity Gold versus Porzio. Noting arguments on appeal first raised in reply brief improperly deprive opposing party of opportunity to respond. You have the opportunity to respond to this, so I don't see what the problem is. But I'm not a lawyer, so I don't know if this is an issue or not. Raising new issues for the first time in a reply brief, as Mr. Echard has so clearly done here, is a per se violation of Rule 35. For those reasons, Owens respectfully moves for an order striking Mr. Echard's reply brief in its entirety. In addition, pursuant to Rule 76(1)(a), Owens requests that the court set this matter for an immediate telephonic or in-person scheduling conference. Among other things, the purpose of the scheduling conference will be to discuss whether or not Mr. Echard will be permitted to call several untimely disclosed witnesses. Owens intends to file a separate motion in limine on that issue within the next day. Also, assuming the court does not preclude Mr. Echard from using untimely disclosed witnesses and documents, it may be necessary for Owens to request a continuance of the trial in order to allow sufficient time to investigate and respond to the new and extremely late disclosures by Mr. Echard. Dated April 30th, 2024, and signed by Gingras. So that is his emergency motion to strike and want a telephonic scheduling conference. Here is the good faith consultation certificate, which is basically a verification thing too that Gingras signed. All right, now we are going to go into Woodnick's response/objection to petitioner's emergency motion to strike against request for immediate scheduling conference to Judge Matta. This was filed May 2nd, 2024. And it states, defendant/respondent Clayton Echard, by and through counsel, undersigned, hereby files his response and objects to the plaintiff/petitioner Owens' emergency motion to strike and request for immediate scheduled conference. I like how he doesn't refer to Owens as Miss Owens. Like, I just love it because I don't want to refer to her as that because that's respectful, and at this point she just doesn't deserve that respect. There is neither an emergency nor cause to strike any part of the reply to petitioner's response filed on April 30th, 2024. Not only does Owens' motion fail to conform to procedural rules, neither Rule 29E nor Rule 35A3, but it also fails to acknowledge that when Owens filed a response that, contrary to the explicit court orders, appended her medical records and proclaimed there is no objective medical proof Owens was in fact pregnant. And Owens was pregnant, emphasis in the original. She opened the door for respondent to reply to the same. Put simply, Owens' own medical records are not new evidence to Owens, and only continue to demonstrate that this process has been predicated on duplicity. As for his response/objections, Clayton states as follows. That is true. That's a very good point. How are Owens' own medical records new to her? They shouldn't be new to her because she's the one that has them or created them through arts and crafts. So And just because it's new to her attorney, that's a him problem, that he's not getting truthful communication from his own client. That's a you problem, sir. As and for his response. All right, number 1. Owens' motion to strike does not comply with Rule 29E, nor request the relief afforded by Rule 35A3, Arizona Rules of Family Law Procedure. I always say practice. I don't know why, but either way. A motion to strike is governed by Rule 29E, which permits a party to move to strike from a motion in insufficient claim or defense or any redundant, immaterial, impertinent, or scandalous matter. Owens' motion does not reference this rule, nor does it allege any fact that would justify a strike consistent with the court's authority. Owens' motion also does not comply with the rule it does cite. Rule 35A3 provides that if a party believes they need to respond to matters raised in a reply, it may not respond to a reply unless authorized by the court. If Owens is asking the court to allow her to respond to the reply to petitioner's response to respondent's amended motion for relief based upon fraud, breathe, she needs to request this relief, and Clayton will respond and object, as his verified reply was appropriate and there is no cause for a reply. A reply to a reply to a reply. So we've got lies, 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 fraud, 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 replies, replies, replies. What else is there? Like, as he said, duplicity. The disclosure material was neither untimely nor new. The untimely, Owens' own medical records were properly disclosed to her, footnote 1, specifically in respondent's 7th supplemental disclosure statement, consistent with the court's disclosure deadline, footnote 2, see minute entry dated 2/21/24. It is further ordered setting a discovery and disclosure deadline 30 days prior to the trial. Emphasis added in the original. Yeah, he can bring it up anytime before Friday. Got a couple more days. Consistent with this court's disclosure deadline, which Owens is aware of per her counsel's personal tweets and blog posts and emails regarding the same. And within 24 to 48 hours of receiving this disclosure, the new material, Owens' medical records from 2016, her emails and texts regarding the same, yet another sonogram she shared with the media, well after the date she now seems to claim to have miscarried. A letter from an actual person whose ultrasound she allegedly pirated, and her own communication with her prior victims and the media is not new to Owens, because Owens knows everything she has done, but she does not want to disclose that to her own attorney, especially not to Clayton, Maraschini, Gillespie, and the others, along with Woodnick, nor the court. But it is not new to her what she has done in this case, and all the others. She knows exactly what she's done. But she wants to play dumb. Let's see what playing dumb gets you. The information Owens claims is new are her medical records and a third sonogram she dispatched via email to the media. Parenthetically, the first 2 sonograms were already addressed in the court's proceeding as well as in the underlying motion for relief and are therefore not new to anyone, nor is it the general topic of improperly tampered sonograms. Moreover, Owen testified about being treated by Dr. Chan and that he was a specialist, one for cancer, because they thought I might have precancerous for ovarian something or another. Transcript at 56 and 57, Exhibit 1. That, upon information and belief, failed to disclose her relevant medical history to her expert is not Clayton's doing. It would be paradoxical if Owens being provided her own medical records, which she now seems to deny, as is consistent with her believed modus operandi of denying any conflicting data, constituted new information. Yeah, it's not new. Like, quit playing stupid. Number 2, Clayton's reply appropriately responded to the allegation in Owens' response, to the extent that this court believes that the motion to strike, despite being procedurally improper, warrants further attention. Clayton's reply complied with the requirement that a reply may address only those matters raised in the response, Rule 35A3. In Owens' response, she stated there is objective medical proof Owens was in fact pregnant. Owens was pregnant. Attached both expert records and an affidavit by Owens, footnote 3, which included the sonogram that has been confirmed not to have originated from Smile or Planned Parenthood, and acknowledged that Clayton's motion alleges Clayton believes Owens was never pregnant, and that he asserts she lied about things such as the authenticity of a sonogram image and other aspects of her pregnancy. Clayton's reply concerns the same scope as Owens' response, namely, Owens' repeated assertions that she was pregnant. It is not sandbagging to provide the court information directly responsive to and conflicting with the crux of Owens' response, Rule 35A3, is intended to prevent requesting a different form of relief or raising a claim that would deny the other party an opportunity to respond, not to prevent a party from elaborating on and replying to allegations in the response. Of course, it is understandable if Owens does not want conflicting information surfacing in litigation that, at its core, about allegations that she has fabricated medical records and faked claims that she was pregnant by Clayton. Owens attached her own medical records, expert reports, and made statements regarding the truthfulness of her alleged pregnancy in her response. Clayton responded in kind and with properly disclosed and redacted data as he was permitted to do so under the rules. Footnote 4. Note, Clayton redacted medical records consistent with the court's orders, notwithstanding the fact that Owens continues to unilaterally publish filings and musings regarding the case and court via Twitter, including affidavits that have not been admitted to this court. At trial, the court will be provided with the unredacted ultrasounds in addition to the one already confirmed to be tampered with. The ultrasound video was already admitted as an exhibit during Owens' deposition, and the alleged new sonogram that shows Owens being 21 weeks along was sent to the media. The medical records from Drs. Chan and Yi are on letterhead and contemporaneous with communication from Owens in 2016. So, that is that. 3. It appears that Owens is unable to keep track of her story as the fiction compounds. This is the carnage of what, upon information and belief, is serial pregnancy fraud and efforts to compel relationships. I am not even her. And we have like 20,000 timelines. We have Owens' many timelines from just in the Clayton case. We have many timelines in Gillespie. We have many timelines in Maraschini. Then we have her own attorney's timelines. There's a couple there too because they're all different. Then we have a sonogram timeline. So there are so many timelines that all of us, through black and white evidence proof, are trying to all put together. And we can't get all of them to merge in one coherent thing. And we're always adding things to the timeline. And then things get taken out of the timeline. And it's like, well, how can you remove things from a timeline? Because they either happened or they didn't happen. And why would they even be on the timeline in the first place if it didn't happen? Like, it doesn't make sense. The math is not mathing. Notably, as more controverting data comes out, it is anticipated, based on Owens' counsel's emails and blogs, that Owens will claim that voice something or another. Let's see. That voice recordings are a product of AI and her emails and text were hacked. Yeah, because that's all she has left. And that's not even working either. So, because forensic technology evidence people are able to shoot that in the foot, like, immediately. She can address these alleged and highly disputed concerns at trial, despite what she may claim to explain away these new records. They came from Owens. Her email, her text, her claimed medical records. Whether she now claims they are real or not does not change the fact that she sent them. It does beg the question of the extent of the fraud consistent with someone who has already admitted to tampering with medical records. See ARS 13-2809. 4. The order of protection at issue in the motion for relief was procured based on fraudulent sonogram. Once again, in Owens' motion to strike, she fails to acknowledge that that very sonogram that was the basis for Judge Duty's granting the order of protection has been proven not to have originated from Planned Parenthood or Smile. Owens has since admitted she tampered with it. That there may be more records that are believed to be fraudulent created by Owens is problematic for her. But she published these records and sent them to members of the media. Those actions have consequences. The fraud in the procurement of the order of protection matters require it to be dismissed on the pleadings. The remaining issues in the establishment matter will be adjudicated on June 10th, notwithstanding her anticipated efforts to continue the hearing. 5. There is no need for any scheduling conference. Trial is set in more than a month, June 10th, 2024. The deadline for discovery and disclosure is May 10th, 2024. If Owens has what, upon information and belief, will be a new excuse for why her medical records from 2016 and sonograms she sent to the media in 2023 are somehow fake or the product of AI technology, she is welcome to allege that at trial. This case is not as complicated as the court articulated at status conference in February, and both parties have had more than enough time to prepare to present their cases in June. 6. Clayton is entitled to his reasonable attorney's fees and costs incurred in this action. This improperly pleaded motion to strike is entirely, if Owens' counsel's Twitter is to be believed, more of the unpleasant filings are forthcoming. Trial is scheduled for June 10th and disclosure is still timely. Clayton is entitled to his response or reasonable attorney's fees and costs defending himself against Owens pursuant to statutes. Note, the court already told fees on the motion to compel pending trial, perhaps granting leave to file a China doll affidavit for fees incurred to date would serve to deter more toxic tactics geared only towards expanding the litigation and forestalling the resolution of this case. Wherefore, Clayton respectfully requests the court A. Deny motion to strike of Owens, B. Grant leave to Clayton to submit a China doll affidavit, C. Order such further relief as the court deems just, including sanctions available to the court under Rule 26, Arizona Rules of Family Law Procedure. Respectfully submitted the 2nd day of May, 2024. Signed by Woodnick, and the copies were sent to the correct people. Alright, here is a, let's see, Isabel Rainey, 5/2/24, verification response to motion to strike. I guess MX means motion. Document emailed for signature, email viewed, document signature by Clayton. Agreement completed. All right, and here are the pages out of a deposition from March 1st, 2024. Question. In your medical records, which we are going to talk about as we get to exhibits, you mentioned having, I'm going to butcher this, I'm sorry, polycystic ovarian syndrome. Correct. Who is your doctor that treats you for that? That would be an OBGYN, but I haven't established regular enough care with an OBGYN. But I was treated for the PCOS in San Francisco by a provider. Who was the provider in San Francisco? I was treated by Dr. Chen. He's a gynecologist for, it's like a specialist, one for fertility. No, he's not. He's for cancer. Okay. So that is where she mentions Dr. Chan. Continuing on in the March 1st, 2024 deposition. Yeah, for cancer, because they thought that I might have some precancerous for ovarian. I just can't. Do you recall the last time you saw Dr. Chan? Maybe 2016? Do you recall what street he was on? Because he's going to be a tough name to track down. He was with, I know what practice he was with CPM, California Pacific Medical, and yeah, you would just look up for, I guess it would be a gynecologic oncologist. That's the word I was looking for. Okay. So she's talking about precancerous stuff and that they were looking for it, as what she says in her deposition. Interesting to know, because I will be bringing these medical records up in just a bit. All right. That is the end of Woodnick's objection response to the motion to strike and telephonic conferencing. Now, we are going to start the last filing of this matter thus far, and it is Gingras. Reply in support of emergency motion to strike and request for immediate telephonic scheduling conference. Oral arguments requested in Owens v. Echard. This case is quickly spiraling out of control into an wildly confusing mess. Sir, it has been that way since the beginning. I'm sorry that after about a month on this case, you are just now realizing it. You're a little slow to realize things. Like, I thought you would have realized this like day one, week one. Like, you're over a month in. And you're just now like, this is out of control and confusing. No shit, Sherlock. And you know what is not out of control, unwieldy, and a confusing mess? The truth. The truth is just simple. It just is. That's the thing. The truth is so easy. The purpose of the present motion is to stop this. Then tell your client to tell the truth. At least to you. Because she's embarrassing you. And I don't feel like you're a person that likes to be embarrassed, but then again, you've embarrassed yourself a lot during this case. And you've allowed this woman to screw up your career. Maybe more so than it already was. In short, all Owens asks is that Echard follow the rules of procedure because he has not done so. Mom, he's breaking the rules. The court should strike his reply filed April 30th, 2024 in support of his motion for relief based on fraud. In addition, the court should set an immediate Rule 76.1 scheduling conference to permit these parties to discuss the implications of newly and untimely disclosed evidence from Mr. Echard, evidence which Owens claims is false and woefully fabricated. She would know because she did it. It is false and wholly fabricated. I'm glad she admits that. But it's not false and fabricated by Clayton's side. It is by her own doing. But she forgot to mention that last part, didn't she? Both of these things, striking the reply and holding a scheduling conference, are needed to ensure this case stays on track rather than flying off the rails. Once again, it is Owen's fault that is this way. This would have been easy and done with if she would have just done what she was supposed to do in the beginning. But no, she couldn't. Owen's ego and the fact that she thinks that because she has been able to manipulate the court system for about a decade has her thinking that she's going to be able to come out of this the same way. And she's not, because enough is enough and karma is a bitch. Introduction. To recap, the issue for the court is very simple. Does Mr. Echard's reply brief contain new material that goes beyond the scope of Owen's response? If so, material should be stricken. Before explaining why the reply should be stricken, it is important to understand the posture in which Mr. Echard's motion for relief arose. On March 25, 2024, Mr. Echard filed a motion in the companion case, the Order of Protection matter, the OOP case. In that motion, Mr. Echard asked for relief from the Order of Protection obtained by Miss Owens on the basis of fraud. That same day, Mr. Echard filed a motion in this case, the paternity matter, asking for a joint hearing on the OOP motion for relief. This court granted the request for a joint hearing in a minute entry order dated April 26, 2024. Thus, Mr. Echard's motion for relief is now effectively before this court. Okay, good. Notably and importantly, more than a month after it was filed, Mr. Echard's initial motion for relief was amended on April 26, 2024. See footnote 1. Okay, 1. For context that the court may not understand is why the motion for relief was amended. In its second paragraph, the amended motion suggests this motion is amended solely in the effort to streamline litigation and focus on the upcoming trial. That explanation, which is inaccurate and misleading at best, fails to explain what actually occurred. Specifically, after undersigned counsel was retained, it quickly became clear that the motion for relief contained numerous false statements of fact which appeared to violate Rule 26b-3. While a full discussion of these matters is beyond the scope of this brief, one key issue was Mr. Echard's representation to the court that to date every obstetrician and gynecologist have indicated that they have no records as she was never seen as a patient. Motion at 2:18 through 21. The representation was and is entirely factually false. Based on this, and as required by Rule 26c to b, the undersigned sent a letter to Mr. Echard's counsel demanding the motion for relief be either withdrawn or amended within 10 days, and that if no action was taken, Owens would seek sanctions under Rule 26 rather than facing sanctions for making a false statement to this court. So he's talking about, oh, Woodnick filed this wrongly and all that nonsense, which he didn't.
Mr. Echard amended the motion for relief. While such an amendment is permitted by the rules, it is worth noting, or worth nothing, this decision was essentially an admission by Mr. Echard that his original motion did contain false statements, some, but not all, of which were removed in the amended version. I don't think it means that because this wasn't put in this way that he was saying, yep, I made a false statement. At the point he wrote that, it was a true statement. Maybe later it became untrue because we got some Banner Health Portal P-Stick report. And y'all know how I feel about the Banner Health patient portal. I hate it. Okay, so that is a footnote. I don't think that's a footnote. I think that's just a full-fledged big A paragraph. Okay, so where was I? Okay. After the motion was amended on April 26, 2024, Owens filed her response later the same day. 4 days later, on April 30th, 2024, Mr. Echard filed a reply in support of his amended motion. In that reply, Mr. Echard raised new arguments based on new evidence which was neither mentioned in the original motion nor disclosed prior to the date. Owens now moves to strike the new information on the basis it violates Rule 35A.3. You know what I don't really like? Is introductions, because it just goes over everything. Like, it's good for people that don't know what's going on. It's good for a judge to remind her of what had been happening previously to this particular motion in case they forget, because they see a lot of filings and motions and have many cases. So I understand why they do it, or for some reason a new judge comes in, they have all the info to look at, but it's a lot when we have covered so much on that. I really could leave out the introductions of these motions. All right. Category 2. A. Mr. Echard's reply contains new evidence/arguments not present in his original or amended motions. As explained in the motion to strike, the new information contained in Mr. Echard's reply includes an allegation Owens lied to her own expert, Dr. Medchill, by withholding medical records showing she previously had ovarian cancer, and that as a result of cancer, one of her ovaries was surgically removed. To support this claim, Mr. Echard's reply purports to quote new medical records literally disclosed by Echard the same day as his reply from a doctor named Jong Chung Kale Chan. Once again, they're not new medical records to Owens. They can't be new to her. She's had them since 2016. Mr. Echard claims these new records somehow separately support on the basis of fraud because there is no mention of Chung Kale Chan MD's records for Laura, who reportedly diagnosed her with real ovarian cancer, not something that just may be there. Or Rebecca Yee's MD's records for Laura, who said yesterday, 8/30/16, you received ovary removal surgery, openrectomy of your right ovary, as well as a surgical abortion. Reply, iOS amended motion for relief at 2/9-14. Despite quoting from these records, in his reply, Mr. Echard discloses as part of the 7th supplemental disclosure statement dated April 30th, 2024, the actual records were not attached to the reply. He did not attach them. I will give Gingras that. I think that they should have been attached to Whitnick's response and objection. Accordingly, to help illustrate the problem, one of these newly disclosed records is shown below.
And so, okay. 8:30, My Health Online, Sutter Health. It's to Owens from Dr. Rebecca Yee. Hi, Miss Owens. Yesterday, 8:30:16. Okay. You received an ovary removal surgery and oophorectomy of your right ovary as well as a surgical abortion. Due to your recent medical history, I will wait to confirm pregnancy termination until blood work and a follow-up ultrasound are completed. Although there were no complications during the procedure, as you explained to me, you have already experienced emotional side effects such as extreme fatigue, depression, and mood swings. Those are common, and I would ask your boyfriend to support you in your recovery. Best regards, Dr. Yee. Okay, everyone, if you see your doctor soon, tell them, can you write me a note to my boyfriend or husband, a fiance, whoever, or your girlfriend, wife, or fiance? Can you write them a thing that says that you would ask that they support you during your recovery or during your sickness? Like if you're getting discharged from the hospital or something, have them put that. I mean, it's like a back to work, back to school note, right? They just have these. Support your wife. Oh my God. Okay. That seems unprofessional. She can't do that. She doesn't have a license to do that or judge the situation because she does not have firsthand knowledge. Like, best regards. Oh my Lord. Mr. Echard claims that this new evidence shows Owens lied to Dr. Medchill by failing to disclose her history of ovarian cancer. But therein lies the problem. Owens never disclosed the information to Dr. Medchill because the record is 100% fake. Speaking in percentages is what liars do. We just need to get that tattooed. Maybe make a song about it. All right. Well, yeah, they are 100% fake. I'll give you that. Owens has never had ovarian cancer, nor had she had an ovary removed. We know. Which is why we want to know about why she has documentation saying she did have cancer and she had an ovary removed. Why does somebody who hasn't have records that say that? Because they are 100% fake. We need an explanation from the person who faked them. To eliminate any doubt on this issue, submitted herewithin is an affidavit from Owens in which she avows unequivocally the following points. Okay, so let's hear what Owens' words are because, you know, they're 100% truthful always. All right. The records disclosed by Mr. Echard as part of his 7th supplemental disclosure statement are fake, false, and fraudulent. Yes, they are. Yes, they are. These are not Owens' records. Owens did not create these fake records and does not know who did. Okay. Well, that's been debunked. Owens had never had ovarian cancer and never had an ovary removed. Yeah, we know that too. Owens was previously diagnosed with polycystic ovarian syndrome, PCOS, and in June 2022, she underwent a pelvic CT scan which confirmed both the existence of PCOS and the presence of both ovaries. We know. But that's not what she said in 2016 to Maraschini. Owens did not disclose the existence of a prior ovarian cancer diagnosis because that diagnosis never happened. Yes, we know a doctor never actually diagnosed her with that. So explain yourself. Given that information, the problem should be clear. Mr. Echard has asked the court for relief on the basis of fraud, but rather than playing by the rules and giving Owens fair notice of his allegations and fair chance to respond to those claims, Mr. Echard did precisely what the rules forbid. He tried to sneak view a previously undisclosed information and allegations into a reply brief. In doing so, Mr. Echard not only violated Rule 35A3, he violated one of the most fundamental rules of basic fairness in litigation. To be clear, Owens is not claiming Echard or his counsel fabricated these records, although at this point she can't rule that out. Well, it wouldn't be the first time she's accused them of doing something they didn't do. But the lack of clarity is exactly the point. Owens has no idea what the records are, how Mr. Echard obtained them, and or who originally created them. Owens has none of that information because these records were disclosed for the first time in a reply brief and because Echard failed to timely disclose this information as required by Rule 49B2B. Required supplemental disclosures be made in a timely manner, but in no event more than 30 days after the information is discovered by or revealed to the disclosing party. In any normal case, investigating this strange new development would be fairly easy. Undersigned counsel would simply pick up the phone and call Mr. Echard's counsel to ask where these new records came from. Ask your client. Ask her to tell you the truth and stop lying to you. But oh, she's Miss Perfect and doesn't lie, right? And what, if anything, Mr. Echard intends to do with them? Nothing. We're just trying to figure out what is true and what is not true in this case. That has been what we've been trying to figure out since day one. We understand it's very unclear. But that's because we're relying on your client to tell the truth, which is not going to happen. And nothing will be clear until then. But as explained in other pleadings, Owens' motion to compel lunch, this normal dialogue is impossible. This is so because Mr. Echard's counsel has continued refusing to speak to undersigned by phone for weeks, which severely restricts any collaborative discussion. Unfortunately, this court declined to require Mr. Echard's counsel to speak with the undersigned, leaving this severe communication problem unresolved. Well, maybe if you weren't such a dick, it wouldn't have been an issue. But nobody wants to talk to somebody who's going to be a jackass, because there's no reason for it. You can be a zealous and aggressive advocate, but you can do it respectfully. For each of the reasons, it is fundamentally unfair and improper to permit Mr. Echard to engage in this obvious act of sandbagging. Mr. Echard's action violates the rules of the motion practice, and his failure to disclose this information in a timely manner violates the rules of disclosure. Taken as a whole, Mr. Echard's conduct also violates the most basic principles of due process, the idea of fair notice and a reasonable opportunity to be heard. So now the question for the court is easy to see. What should be done about this? There are really only two options. The first and most obvious choice is to require Mr. Echard to follow the rules. You know what it would also be the first and most obvious choice? Is your client to tell the truth. This means the court should strike the reply on the basis it violates Rule 35A3 and furthermore on the basis that the information contained in the motion was not timely disclosed under Rule 49B2B. I think she knows what that means because you said it previously. But I guess we treat judges like they're dumbasses too, apparently. Of course, that may not permanently resolve the problem. Mr. Echard may still choose to bring a new motion for relief under Rule
85B2 on the basis of newly discovered evidence based on the same fake records. Alternatively, even if he does not bring a separate motion seeking a place, these fake records bring a separate motion seeking to place these new fake records before the court, presumably by Mr. Echard, will still attempt to offer them at trial. Under these circumstances, to ensure a permanent solution, the court should immediately set this matter for a scheduling conference for the purpose of asking Mr. Echard to explain his intentions regarding the records. He has no intentions except for trying to figure out what the hell is going on. Depending on his position, Owens must have a fair chance to respond, which may include seeking a continuance of the current trial date. To avoid confusion, Owens' position is as follows, as explained in the motion in limine filed on April 30th, 2024. Mr. Echard is trying to establish Owens' guilt in this case by offering prior acts or propensity evidence from previous relationships and these newly disclosed records, while fake relate only to the same argument, proof of prior acts. No, it shows a pattern of behavior that she's continued to do and get away with. And it's meant to have her stop the bullshit. Excuse my language, but I am so fed up with Owens and Gingras and all their crud. It's just so ridiculous that they can even say the things that they say. Evidence from Owens' past relationships is simply inadmissible in this case under Rule 404B, and also because it's entirely irrelevant. For those reasons, among others, including the fact that this evidence was not timely disclosed, the best solution is for the court to preclude this evidence in its entirety. If the court agrees with that view, Owens would be fully prepared for this case to proceed to trial on June 10th. On the other hand, if the court is inclined to allow Mr. Echard to use evidence alleged prior acts, including fake medical records disclosed by Echard for the first time just days before the existing disclosure cutoff, Owens must be allowed a full and fair opportunity to invest, perform discovery, and develop a full response. That would necessarily require continuing current trial date by at least 60 to 90 days. Well, we got an expert. You want to do a deposition on him? Or it would make a lot easier to respond if Owens would just tell the truth. Owens does not want to move the current date, but that may be unavoidable depending on how far afield Echard is allowed to go with respect of evidence to Owens' past relationships. That is why a scheduling conference is so clearly necessary. And the thing is it goes to show her credibility and the fact that she has doctored medical evidence before. It's not a one-time thing, and this needs to be taken very seriously. And so that's what I think it goes to show. Like, does that, as far as the information in it, does that stuff really matter? No. But I think the fact that it shows what she's done and it's a pattern, like, because that is, Woodnick and Clayton's strategy in this case is that she does this stuff. And she has continued to do it, and she has former victims, and Clayton is just another one of those victims in this long scheme of things that she does. That is what their theory is, and they're trying to prove. So I think this evidence does go to prove that. But, I don't know. I don't know if, in the long run,
the medical information on it goes to show that or what, but I think the fact that the document exists should be considered. So maybe judicial notice of the document if she will admit to doing it, like she admitted to doing the sonogram. But that blows her credibility on everything, even more than it already is, because she would have 2 confessions. But in conclusion, for the reasons stated above, the court should strike the reply filed by Mr. Echard on April 30th, 2024 in support of his amended motion for relief based on fraud. In addition, pursuant to Rule 76.1a, the court should set this matter for an immediate scheduling conference at its earliest possible date to formulate a plan for trial, including procedures for facilitating the admission of evidence. Signed, Gingras, and copies were sent to the correct people, dated May 3rd, 2024. So there are 3 motions that go with that thus far. And we are going to end with our quote of the day. Characterize people by their actions, and you will never be fooled by their words. It's a practice what you preach. I don't need to hear sorry. I don't need to hear you won't do it again. I don't care about your words. Show me. Don't tell me you love me and you care about me. Show me you love me and you care about me. And I live by this because I have been with people who try to gaslight and lie to you. And they just say whatever they can to try to get them to be on your good side again, or you to believe and trust them, and then they break your heart over and over and over again. I've done it with my kids. Don't tell me your room is cleaned, show me your room is clean. If I'm at work and you tell me that your room is clean and you're wanting to go somewhere, I'm not going to take your word that it's cleaned, because clean could mean shoved under a bed, shoved into a closet. Send me a video of your room and every place in it that it is clean. Because how many moms have our kids said, oh, my room is clean, and then we've gone in there and it's like, what is your definition of clean? So watch people and their actions. You can listen to their words too. But if you watch people and who they are and what they do and what they are, their words won't fool you, because you'll be like, except for that's the opposite of what you do. Your words are a contradiction to your actions. And that's how we have judged Owens here. That's how we judged Heard. Oh, believe what I say. Don't pay attention to what your eyes see that I've been doing. And I'm sorry, we just cannot live that way. So we are going into this world with our eyes opened, so that we can surround ourselves with better people. That is it for today. Like this video, subscribe, and I will see you in the next one. Bye.